In the case of Stevens versus the Porton Construction Company, there has been a dramatic turn of events. George Walker, a prime witness for the defence, has just committed perjury. Having initially said that the shed containing safety belts was open, he now admits that it was locked. Walker has tried to place the entire blame on his managing director, Charles Porton, claiming that he was acting on his instructions. Charles Porton has given evidence denying strongly that he ever gave instructions for the men to be sent back up to work. He contends that if the plaintiff, Jack Stevens, together with Tom Morgan and the rest of the men, went back onto the bridge, that they did so voluntarily and contrary to express instructions. Therefore, neither he nor his company can be held responsible for the accident that occurred.
Yes, Mr. Lloyd.
Mr. Walker, during the construction of the bridge, your wife continued to reside in London.
Yes, she did.
Will you look at this document?
Before the witness sees it, my lord, I'd like to know what it is.
My lord, it is a letter written by Mr. Walker. The plaintiff has had paper notice of the intention to use it in evidence, but my learned friend can see it if she wishes.
Proper notice has been given, Miss Tate?
Yes, my lord.
Mr. Walker, will you look at this document? It is a letter written by you to your wife just 2 days after Stephen's accident, isn't it?
Yes.
Now, would you read the part that I've marked, dealing with the accident?
After I told them about the gale warning, the men wanted to go up again. I told them I would not allow it, but they went up without my authority. Jack Stevens fell and is now paralyzed.
They went up without your authority. Thank you. You needn't read any more.
Mr. Walker, which of your stories is true?
The one I said yesterday.
So you lied in that letter to your wife. Why?
Well, I knew she'd get to hear of it. I didn't want her to think I'd sent the men up.
That was the reason?
Yes, sir.
Have you anything else to say?
No.
Then you can go, Walker. Mr. Lloyd, do you wish to recall Mr. Porton?
Well, I will simply tender him for further cross-examination, my lord.
All right, come back, Mr. Porton. Porton, you are still on oath, you understand?
I do.
I expect you're wondering just what I'm going to ask you, Mr. Porton.
No, madam. I imagine you're going to ask me about the misleading statements of the previous witness.
Misleading statements? Well, I must say that's a rather delicate way of putting it. Yes. But before going into these misleading statements, there's one or two things I'd like to ask you about your previous evidence. Now, his lordship has asked the defendants to produce an employment register so that we can verify a statement you made.
This register has been produced?
Indeed it has. My lord, if the jury may see this, the relevant page is marked. Now, you stated, Mr. Portman, that your company did not employ men over the age of 45. And at the time of employment, Jack Stevens gave his age as 43.
Yes.
I take it you meant to imply that had he given his correct age, he would never have been employed in the first place.
Yes, that is correct. In fact, it has been pointed out to me that I gave written notice of this fact to my site foreman over 7 years ago.
Yes, well, it's a little late in the day to introduce that point now.
No, I'm sorry. I can produce...
Let's just deal with the register, shall we, Mr. Porton? Have you actually seen it?
I have now.
And have you noticed that on the relevant page, all the threes are well-rounded, with one exception, that of the 3 in the 43 opposite Jack Stevens' age. This begins with a straight horizontal line, as if one was writing a figure 7. Whereas all the other 3s are well-rounded. Have you noticed that?
No, I can't say I have.
I see that, please. Mr. Porton, has this record been altered?
Not as far as I'm aware, my lord. But then I saw it for the first time today. I was given the information verbally and accepted it as being accurate.
In whose handwriting is this?
Well, the whole book has been made out by the site foreman, Mr. Walker.
I see, thank you. Carry on, Mr.
Obliged, my lord. Where was this register kept, Mr. Porton?
At the site, in Mr. Walker's office.
No, I mean when the bridge was completed.
Oh, it was filed away with all the other records, as usual.
In your office?
Well, not in my office itself, in the same building, yes. Was it freely available?
Oh, yes.
Oh, yes. The accounts department often had to refer to the register for several years after a job has been completed. National insurance, tax queries, that sort of thing.
So had you wished to, you yourself could have gained access to that register.
But, my lord, I really must protest.
Quite so, Mr. Lloyd. Miss Tate, are you in possession of evidence that we have not yet heard?
No, my lord, I merely wish to emphasise the fact that the register was available to everyone, from office boy to managing director.
Then your question was most unfortunately phrased. Mr. Porton has already said the book was freely available.
I apologise, my lord. I'll withdraw the question.
More important, members of the jury, you will immediately dismiss from your minds the implications contained in that question.
Mr. Porton, I previously asked you if the penalty clause in your contract was covered by any form of indemnity, and you said you weren't sure, but you thought it must have been. Now, have you had a chance since to check this point?
Yes, as a matter of fact, I have. It seems I was completely wrong. My accountants now tell me that we didn't take out an indemnity because the penalty clause was small, and also we'd obtained a long completion date. On top of all this, in the initial costing, we had overestimated on man-hours, and that in itself was an insurance.
Mr. Porton, do you think you could explain that in layman's terms so we could all understand?
I'm sorry. Well, in the initial costing, we had estimated that a workforce of say, X men could finish the work in 18 months. Later examination proved that there was a mistake. The same workforce could finish a job in 17 months. So, as we had time in hand, it was thought that we could dispense with the indemnity.
I see. But despite this initial error, you were still behind schedule on March the 15th, were you not?
Yes, but as I've already explained, with a contract this size, one is constantly either ahead or behind schedule. It was just a slight setback, that's all.
I'd wholly call it a slight setback, Mr. Porton. You'd not only lost your initial month's grace, but you were behind schedule as well.
Well, the important thing is that the bridge was finished, surely.
But you were not to know this on March the 15th, Mr. Porton. Now, in your own admission, the road contractors were anxious and needed reassuring. There was this penalty clause hanging over your head, which we now discover was covered by no form of indemnity.
But at that particular time, I was completely unaware of this fact. I've only just...
Oh, come now, Mr. Porton. You're not asking us to believe that you, the managing director of the company, didn't know such an important fact?
Well, I assure you that it is so. You know, the details like this, the day-to-day running of the company, I leave to my managers. My function is purely administrative.
So much so that you call at one of your sites to have a discussion at 8 o'clock at night with the site foreman?
I called at the site simply because it was on my way. I'd heard a gale warning, and I wondered whether the bridge had been linked up. It was as simple as that.
Ah, yes, this gale warning that never was. Now, you say you heard it on the radio, I believe?
Yes.
At what time?
Oh, about 6 o'clock.
Now, the Meteorological Office, who issue these information which is broadcast, gave no gale warning that day for the Carron area of either Force 8 or Force 9.
I don't understand.
I think you understand very well, Mr. Porton.
Miss Tate, just what is the status of this document for the purposes of the rules of evidence?
The document has been agreed between the parties' solicitors, my
You
lord.
mean the facts have been agreed?
Yes, my lord.
Then I should like the witness, the jury, and Mr. Lloyd to have copies, please.
Thank you.
Well, Mr. Porton, do you see any Force 8 or Force 9 gale for the Carron area?
Well, no.
Of course you don't. Because it was pure invention on your part, wasn't it?
No. I heard it. I swear I did.
I suggest that you fabricated this whole story in order to get your own way and get the men back to work that night.
No. Look, there must be some mistake.
The only mistake, as far as you're concerned, Mr. Porton, is that we took the trouble to check this mythical gale.
No, I heard it.
Well, I'd like to move on now, if we may, please.
Here, I
Mr.
see.
Porton.
No, please, my lord.
I think the witness should be allowed to speak, Miss Tate.
Of course, my lord.
Well, it's here. Force 8 increasing to 9, Shannon area. Shannon. You see, I obviously misheard him, thought he said Carron. I mean, Shannon and Carron sound very similar.
Do they?
Well, yes. Yes, of course they do.
Well, I'd like to go back now to your meeting with Mr. Walker on the night of March the 15th. Now, Mr. Walker states that you sort of suggested that the men should go back to work.
That's quite untrue, madam. I neither said, suggested, nor implied any such thing. I would have only asked the men to go back to work if the weather had deteriorated to such a degree that the bridge was in danger.
Then why raise the matter of the impending gale at all?
Because there was a possibility that we might have to take action. I was merely forewarning him.
Well, are you saying then that Mr. Walker misunderstood you, that he took the reference to the future as referring to the present?
No, he understood me very well. I mean, that is why we agreed that if the gale blew up, he'd send the men up at first light.
Of course, Mr. Walker has viewed this conversation very differently. He even suggests that there was an implication of promotion on your part.
Yes, I heard him. The only talk of promotion that night came from Mr. Walker. As I was leaving, he asked me whether I had made any decision yet.
And how did you answer?
Well, I told him I hadn't made up my mind. At that time, we were considering another man. Walker knew this.
So you're saying that you made no promise to Walker, either veiled or otherwise?
Definitely not.
And yet the fact still remains, Mr. Porton, that Mr. Walker was in fact promoted 1 month later.
Well, he was a better man, that's all.
A man with the company's interest at heart.
I meant that he was better suited to the position, nothing else.
Now these safety belts, are they expensive?
Well, for what they are, and considering they're hardly ever used, yes, I suppose they are.
But of course you're compelled by law to provide them, aren't
Yes.
you? So I suppose you were rather annoyed when they were stolen.
Annoyed, no. Equipment is frequently stolen from a site. It's one of the recognizable hazards.
Oh, but surely being the astute businessman that you are, you wouldn't just sit back and let all this pilfering go on unchecked. You'd surely have done something about it.
Of course. In this case, I suggested to Walker that he got the men to sign for the belts when he had them, so that he could keep a check on them.
You mean that a man would ask Mr. Walker for a safety belt, he would issue it, and then they would sign for it?
I didn't go into the details. It was merely a suggestion I threw out when I heard of the theft. Walker knew as well as I did that the belts had to be freely available. All I know is that whenever I was on the site, they were.
And yet Mr. Walker says that it was frequently locked. I put it to you, Mr. Porton, that you were so annoyed about the theft of these safety belts that you ordered a lock to be put on that door.
No, madam.
Well, are you saying that Mr. Walker put the lock on the door on his own authority?
Well, he certainly didn't do it on mine or on the authority of anybody in my company.
Nevertheless, you do admit that there was a lock on this door.
As there is on any storeroom.
And if the door is locked, then how can these belts have always been freely available?
Well, because when the shed is always open when the men are on duty.
You can swear to that always?
Well, of course I can only actually swear to what I've seen. All I know is that whenever I was at the site, the shed was open and the belts were available. I've already said this.
But you were not at the site when the men went back to work, Mr. Porton.
No.
And yet when Morgan accuses Walker in front of you, you glibly tell him to go and check the safety belt shed for himself. Now, how could you know that it was open?
Well, because I heard him say so. I took his word for it. I mean, I'd employed the man for years. I trusted him. All I knew about Morgan was that he was a troublemaker, a communist. Man was obviously trying to stir things up. He's a born agitator.
You certainly don't like Mr. Morgan, do you?
No, madam, I'm afraid I don't. And then I'm sure he doesn't like me.
So on the word of your trusted employer, on his word alone, you tell Morgan to go and see for himself that the safety belt shed is open.
Yeah?
You really must have been very certain of Mr. Walker. Or had you, in fact, been near the safety belt shed yourself that night?
Nope.
Or did you know that the shed was open because you'd asked Walker to open it?
No.
And yet George Walker, your trusted employee, the man who you promoted, the man on whose word you trust, has stated on oath that he unfastened that safety belt shed on your order. Now why? Why should he invent such a story? By saying this, he has absolutely nothing to gain, rather a lot to lose. Now, can you give the court one valid reason why we should believe your story rather than his? Can you, Mr. Porton?
Yes, madam, I can. I'm sorry to have to say this in public, but I feel that the whole thing is an act of pure vindictiveness on his part. Well, the truth of the matter is that his promotion was a mistake. I've known for some time now that he's simply not equipped for management. I think he must have heard that I was looking for someone to fill his position. His pride was hurt. He wanted to hit back and harm the company as much as he possibly could. Unfortunately, he was not to know that he would have been retired on full pension. I believe that is the only explanation of his incredible behavior.